Salutations to all our future judges. In this video, we are going to see Indian Evidence Act 1872. But before going into the video, I'd like to make few requests to our viewers as well as the subscribers. Kindly do not skip the video. Watch the video from the beginning till the end. If you skip in between, you may be missing very crucial information or very crucial aspects which have been explained. Hence, watch from the beginning till the end. And next request is, please do have a notebook and a pen with you, because various questions which have been asked in Evidence Act in various exams would be mentioned or would be stated. And in addition to this, idea would be given as to how questions could be framed in a particular section. It is very important for you. So you all need to make a note of all these aspects. And in addition to this, some additional illustrations would also be given while teaching the act. Hence, you please make a note of all those additional illustrations as well. They would be of absolute help to you in understanding the particular section. And in addition to this, various ways or techniques would be taught which would help you to remember those sections, or to say some memory techniques would be given. This would be really helpful to you in remembering the sections when you go to the exam. I hope this video would be of absolute and great utility to you. Part 3, Production and Effect of Evidence, Chapter 7 of the Burden of Proof. Section 101 speaks about burden of proof. So, if there is a person who goes to the court and says that he has got a legal right, or he says that the other person has got a liability, or the defendant has got a liability against or towards the plaintiff. In that case, the person who goes to the court, who wants the court to give a judgment pertaining to a legal right or liability, has to assert to the court that there are certain facts which are existing which makes that legal right exist or the liability exist. They are given some illustrations. Let us see what those illustrations are. Illustration A. A is going to the court. A person called A is going to the court, and he is saying to the court that B has committed a crime, and he requests the court to give a judgment saying that B should be punished for that particular crime. Then in that case, A must prove that B has committed the crime. So he is going to the court and saying that the judgment should be given against B. Then A should prove to the court that such a crime has been committed. Now let us move to the next example, B. Now imagine there is a land in which B is having the possession, or he is occupying that particular land. Now one person A goes to the court and says that the land which B is in possession actually belongs to me. I am entitled to that land. But B says no, he is not entitled. Then in that case, A must prove the existence of those facts based on which he is claiming his entitlement over that particular land. Section 102, on whom burden of proof lies. The burden of proof in a suit or proceeding is always on the person who would fail if no evidence were given at all in the suit or proceeding. They are given some illustrations. Let us try to understand this concept by way of those illustrations. Now, there is one land. B is in possession of the said land. A goes to the court and sues B, saying that one person by name C has written a will in his favor, and this C is the father of B, and based on this will, A is entitled to that land. If no evidence were given on either side, B would be entitled to retain his possession. That is, A will fail if he does not produce any evidence. Therefore, the burden of proof is on A. Next illustration B. A sues B for money due on a bond. So this B has given a bond to A, saying that I will pay you this much money whenever you demand. But he has not paid as accepted. So A is going to the court and saying like B has taken money from me, he has executed a bond also, he is not paying the money, then in that case, the execution of bond is admitted by B. B says, yes, I did write a bond and I did execute it. But he says, it was obtained by fraud. A is denying this fact. If no evidence was given either by A or by B, then A would succeed, as the bond is not disputed and the fraud is not proved. Therefore, the burden of proof is on B. Now, let us move to section 103. Burden of proof as to a particular fact. Imagine if I want to prove to the court, or I want the court to believe that a particular fact exists, then it is my duty to prove to the court that such a fact exists. However, if the law states that I need not prove it but somebody else has to prove that aspect, then in that case the other person has to prove it. Now let us see some illustrations to understand this particular concept. A prosecutes B for theft and he wants the court to believe that B admitted the theft to C. Then A must prove the admission. Let us try to understand this in a much more simple fashion. A person is filing a case against me and he wants the court to believe that I was involved in a theft, for which he is relying upon a statement which I gave to C, wherein I stated to C, Mr. C, I have done this theft, I did do this, I felt bad about this. I made an admission to C. And this A has seen it happen, or A came to know that I have made an admission to C. In that case, the person A has to prove to the court that I made an admission to C. Illustration B. Now, a case is being filed against B. He is being accused of some offense. But this B says to the court that I was not present here at that time. I was elsewhere. Then in that case, the person who says that he was elsewhere should prove it to the court. This is section 103. Section 104. Burden of proving fact to be proved to make evidence admissible. I need to prove something to the court to make my evidence admissible. So the simple fact is, step 1 is there, where I should prove a particular fact. Then only my evidence will be admissible. Let us try to understand this by way of the illustrations which are provided. Illustration A. A wishes to prove a dying declaration by B. So, when someone is trying to prove a dying declaration, he should prove that the person has died. It's very important. The next thing is, this is illustration B. A wishes to prove by secondary evidence the contents of a lost document. So imagine I have lost a document. I am trying to prove this particular document or the contents of the particular document by way of a secondary evidence which is permissible. And in that case, I should prove to the court that my document is lost. That is very important. This is section 104. Section 105. Burden of proving that case of accused comes within exceptions. Imagine a criminal case is being conducted in the court. Then this accused is saying, I am falling under the exceptions provided under the Indian Penal Code, so you cannot punish me because I am falling under exceptions. So in that case, the accused has proved to the court that he is falling under these exceptions, failing which the court will presume that this person has committed the crime. They are given some illustrations pertaining to this. Let us understand those illustrations as well. Illustration A. A is accused of a murder. He goes to the court and says, I had unsoundness of mind. I did not know what I did. I did not understand the nature of the act which I was doing. I am falling under exception. So in that case, this A has to prove to the court that he had unsoundness of mind. Next, illustration B. This A is accused of a murder. He goes to the court and says, I had grave and sudden provocation and I was unable to control myself. I didn't have the power of self-control at that time. So he's saying that I'm falling under an exception. In that case, this A has to prove to the court that there was a grave and sudden provocation due to which this murder was committed. So again, the burden of proof is on A. Illustration C. So this section 325 deals with voluntarily causing grievous hurt. However, there is an exception under 335. So, if someone is saying that I am exempted under section 335, so the person who is claiming a right under 335 has to prove that he is falling under that particular exemption. Section 106, burden of proving fact especially within knowledge. So, when any fact is especially within the knowledge of a particular person, he has to prove it to the court. The burden of proving is on that particular person. Let us understand this again by way of illustrations. When a person does an act with some intention other than that which the character and circumstances of the act suggest, the burden of proving that intention is upon him. Let us try to understand this. Let us make or create a new example to understand this particular example. There is an accident in a road. One person who is traveling in his vehicle, he is seeing that an accident has taken place. He stops his vehicle. Then he goes there and is trying to see as to what has happened. Then he is seeing that a person with injury is lying on the road, bleeding. So in that case, this person goes and starts beating that person who was bleeding. Then, in that case, he has to prove to the court as to why he started beating that person. Generally, if a person is having an injury or bleeding, people tend to take him to the hospital. People tend to give him first aid. Instead of doing this, he is going and beating that person. So in that case, the person who started beating him has to explain to the court as to why he did like this. So generally they don't tend to do this, but he is doing something different. In that case, the person who is doing the different thing has to explain to the court as to why he did this. Next is illustration B. This person A is charged with traveling on a railway without a ticket. So a person goes into the train without buying a ticket. This ticket checker or the ticket collector comes into the train and he catches hold of him. Then in that case, the burden of proving lies on the person who traveled without a ticket. So he has to prove to the court that no, I did travel with a ticket. This ticket collector has wrongly caught hold of me. I did have a ticket and this is my ticket. He has to prove to the court. That is very important. This is section 106. Section 107. Burden of proving death of person known to have been alive within 30 years. Now there is a question in the court whether a particular person is alive or dead. And it is shown to the court that he was alive within the past 30 years. So in that case, the person who is claiming that person to be dead has to prove to the court that that particular person is dead and is no more. And burden of proof is on that particular person who is claiming the death of a person. Next is section 108. Burden of proving that person is alive who has not been heard of for 7 years. Now, let us try to understand this particular section by way of an example. There is a boy who has been living with his parents for say some 10 years. Suddenly, for 7 years, he is not heard by his parents. They tried to find him out, they gave a police complaint, they even went in person and searched in so many places where he could be residing or where he could be living. So, they tried their level best and they couldn't identify this boy as to where he went. Then, in that case, they believe that this person is no more or this boy is no more. So, in that case, there is another person who is coming to the court and saying, no, I saw this person or I saw this boy somewhere else. Then in that case, the person who says that I saw this boy to be alive has to prove to the court that where he saw this boy and how he saw this boy, and is there any other person who also saw this boy, or is there any proof, records to show that this boy is alive. Section 109. Burden of proof as to relationship in the cases of partners, landlord and tenant, principal and agent. Let us try to understand this section again by way of an example. Imagine there is a landlord A and a tenant B. There is a case between these two people. Now, the landlord is going and saying in the court that he is not my tenant. So in that case, the tenant is showing document to prove that these two were acting as landlord and tenant. That is, A was the landlord and B was the tenant. Then in that case, landlord is denying this. In that case, the landlord who is denying this relationship has to prove to this court that such a relationship never exists. I hope you would have liked the video. If you like the video, please do press the thumbs up button and do share the video with your friends and motivate them. If you are not subscribed the channel, please do subscribe the channel and share the channel with your friends. If you feel that I've left something in this video or you want me to change the way in explanations are given for the sections, please do let me know by way of comments. Let us join hands together and contribute for a learned society. Thank you.